Welcome to Brief Encounters and to Season 2 of the Securities Regulation and Enforcement Series. My name is Valerie Mirko. I'm a partner at Armstrong Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation Practice. And with me is my co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, thanks, Valerie. William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisors Association.
And I will note that today is March 14th, and this episode will come out on March 26th, which, we usually have about a 10-day lag between recording and release of our episodes, which usually that kind of lag does not really affect how timely our episodes are, but here in March of 2025, it might. So I'm going to kick it off with the thing that all of us who are here in DC, whether we are attorneys, lobbyists, or other practitioners related to the business of Washington, are talking about this week, which is whether there might be a government shutdown. William, can you speak a little bit to that?
Yeah, absolutely, Valerie. So yeah, I think it's on everyone's mind, but especially being in DC, I feel like it's something that, we're inundated with every day. But, surprisingly to most folks, the House of Representatives actually passed a government funding, what they call a continuing resolution, which would fund the government until September. Now, as Valerie said, that funding for the current year end for the government runs out Friday, actually tonight at midnight. The Senate has still yet to vote. We've seen some signs that there may be enough Democrats that will support the continuing resolution, which would mean no government shutdown. But again, at this point, until the Senate votes, we really don't know. So by the time this episode actually is published, we may have had a government shutdown. It could potentially still be going on, or, it could be business as usual. So kind of a wait and see moment for us. But, I think another thing to touch on before we start talking about some of the executive and administrative orders that we've seen that would impact the SEC, we still are waiting on the nominee for SEC Chair, Paul Atkins. We have heard that he may come up for hearing, oddly enough, on March 26th, when this podcast will be published. But again, the hearing hasn't been noticed yet, so we'll kind of have to wait and see. But they do really want to have formal SEC chair appointed within, the next few weeks or within the month. So, but Valerie, I want to throw it over to you now. We saw, I think it was back on February 18th, an executive order which would have, pretty drastic impact on the SEC. And basically, it could impact its independence from the administration. So could you talk a little bit about that?
Of course. And, I think you're exactly right in that while the government shutdown is everything that we're talking about this week, we also have to sort of look at the longer term impact of everything that's been happening since January 20th. And one of that is the February 18th executive order, which is about independent agencies. So as everyone who listens to this podcast knows, the SEC is an independent agency such that while the chair is generally appointed by the current administration, we've seen commissioners stay in their commissioner roles well beyond their appointments because of the way that commissioners are appointed. And also in practice, the SEC is not an executive agency such as, the Department of Labor or the Department of Education. It is meant to be an independent agency that has both parties within its commission. The February 18th executive order speaks to bringing that independence under executive authority and specifically references rulemaking and enforcement. The rulemaking aspect of the order speaks to how rules now need to be reviewed through the executive branch. That would be very unusual and a complete departure from currently how SEC rules are subject to, proposal, notice, and comment. And with regards to the enforcement component of the executive order, there's some language that speaks to how agencies and their employees cannot apply existing law and regulations in contravention to policy. So, of course, when we read this, we immediately think of what's been going on with crypto, where we've gone from a very adversarial environment for the crypto industry to one that is far more open. And we'll talk about that in future episodes. But that could also extend well beyond crypto in terms of how enforcement is handled by the SEC moving forward. That said, I've seen sort of no immediate impact of the February 18th executive order in my interactions with the staff in recent weeks. I think it may have a further ranging impact over time, but I think that's an open question, right? To your point, William, like there's executive orders, there's other directives. Some are more typical and some are less typical. I put the February 18th executive order in the atypical category where I think it will take a while to see how it moves forward. I certainly do not think there will be much rulemaking occurring, definitely not at the pace of the last commission when Gensler was the chair. But William, can you talk a little bit about executive orders we've seen in recent weeks and months that are more typical of a change in administration?
Yeah, absolutely, Valerie. And there has been a lot. Now, again,
Indeed.
I know this podcast isn't coming out for 12 days, which in normal times, as you said, Valerie, I don't think we'd have to be too worried. But at least as of today, there have been 128 executive actions. Now, whether that's executive orders, administrative memos, other types of directives. So again, my calculation today could be woefully out of date by March 26th. But so far what we've seen, of the more typical executive orders on day one, generally a new administration will implement what they call a regulatory freeze. They want the new administration to come in. Any work that's currently being done is stopped. Any rules that have been sent to the Federal Register that are not effective can be withdrawn or reviewed. So again, that's a pretty typical executive order. That's been done. That was done by the Biden administration, the Obama administration, the first Trump administration. So again, pretty typical. Now, other executive orders we've seen, I would say, are a little bit more atypical, like the executive order at independent agencies. The first is executive order that's called prosperity through deregulation. Now, this would require any agency that wants to issue any type of rule, they'd have to actually go back and find 10 rules that they'd have to somehow withdraw. Again, I don't know how that would work in practice with the formal rulemaking process that agency has to go through. And again, this was an expansion from President Trump's first administration, where he had an executive order for one new rule, and you'd have to go back and find only two rule to withdraw or modify. So again, he really upped that. Another executive order I can talk about is called the DOGE Deregulatory Initiative. This is something where the administration wants all agencies to go back and basically do a holistic review of the rules in place as of now. Look, if any that they deem, say, hey, maybe, we didn't have the authority to issue these rules. Maybe, we believe, now that they're unconstitutional. It's just really a broad, holistic review to align with the current policy of the administration. The third, and I know Valerie touched on this, but there was a digital financial technology executive order. This administration is very supportive of digital assets, cryptocurrencies. They actually created the White House Working Group on digital assets. They just had a big White House Council last Friday. And we've also seen it at the SEC as well. Commissioner Hester Peirce is currently leading the SEC's cryptocurrency task force. They actually have their first roundtable a week from today, on March 21st. So again, we have seen some of these executive orders, but Valerie, to your point, I completely agree. It's going to be difficult for us to kind of see the impact of these. I think, it could be months or even, years, because, the administration is in place for 4 years. So even if you have, these 100 plus executive orders within the first 6 weeks, I think you will, need to take time to see, how they ultimately will impact the administration as a whole, but specifically the SEC. And on that note, the SEC has also been pretty active. And I know recently the SEC actually finalized a rule that would eliminate any kind of delegation of enforcement authority to the enforcement director, and they would need to go through the commission for any kind of formal investigation or formal order. So I didn't know, Valerie, again, in your practice, you're much more steeped than I am. If you could kind of talk about maybe, what you've seen so far and what you believe the impact of that order may be.
No, that's exactly right. And before I dig into the order that removes the delegation of authority to the director of the Division of Enforcement to issue formal orders of investigation, I did want to touch on one last point of rulemaking, William, which is we expect rulemaking to slow down considerably. But I think the reality is the SEC does want to put certain new rules into place, particularly around digital assets. And I do not think that aspect of rulemaking is going to slow down or other ancillary issues to that area. So I don't want the takeaway from today's episode to be that all rulemaking will slow down. I think it is just going to be following a different cadence and process than we've seen in recent years. And that will take a while to work itself out. What do you think, William?
No, and I think that's absolutely right. And I think, kind of a theme throughout some of these orders, really it's the administration trying to align the agency's, policies, whether that's enforcement, whether that's rulemaking, and even, to your point, Valerie, moving what's historically been an independent agency with a bipartisan commission more in line with the political whims of the current administration. So again, I completely agree that while rulemaking will slow down for some issues, it actually may speed up for others. So yeah, it's going to be really interesting to see over the next few weeks and months kind of how that plays out.
I think that's exactly right, William. So moving to this enforcement delegation, because that has been in the headlines quite a bit in recent weeks as it was brewing. Even beginning as early as February 2nd, we were seeing articles in the sort of the industry media that was saying that SEC enforcement attorneys had been told that they would need the approval of the Commission for all formal orders of investigation. Those of us who practice in the enforcement defense space were all looking back to 2009, which is, of course, when the SEC delegated authority to issue a formal order of investigation to the then director of enforcement. So it's important to look at this historically, right? As of just a few days ago, on March 10th, the director of enforcement no longer has delegated authority to issue a formal order. Before 2009, that was exactly how things were at the SEC then, too. Before 2009, the commission approved formal orders of investigation, and there was no delegated authority to the director of enforcement. In 2009, there was a 1-year rule delegating that authority, which was then made essentially permanent in 2010. So I think we have lessons to look at from pre-2009 in terms of the business of the enforcement division and how they conducted investigations when the enforcement director did not have authority to issue a formal order. And I'll get to that in just a minute. The other thing I wanted to note is the rule itself is specifically about removing the delegation of authority to the director of the Division of Enforcement. However, by chair directive, there have been phases in the last 15 plus years where that authority was expanded, again, by directive, not by rule, to include also 15 to 20 of the most senior officers in the Division of Enforcement, which means that, and William, you and I were talking right before we hit record on this episode, I've had instances in the last few years where a formal order of investigation against one of my clients was not necessarily signed by the director of the Division of Enforcement. It might be signed by the deputy director, it might be signed by a regional director or other senior officers. So there have definitely been variations. And by removing that authority from the director of the Division of Enforcement, those variations are going to go away. And in fact, we did see in the news, it was mentioned that authority was already getting rolled back from the senior officers before the rule was changed on March 10th. But this is all to say that the new posture going forward is the commission is now approving formal orders of investigation as opposed to the director of enforcement or as opposed to other senior officers of the Division of Enforcement. But what does this mean in practice? Pre-2009, those of us who did this work would tell you that there were more informal interviews. Informal interviews, however, how informal are they really? Because the reality is, especially if a registrant, such as a broker dealer or an investment advisor, receives a request for an informal interview or a document request as opposed to a subpoena, the reality of saying, no, we will not respond to this is more than likely to result in a formal order being approved by the commission and in a subpoena being issued. So while the revocation of the authority of the director of enforcement to issue a formal order is a big change and takes us back to pre-2009 in terms of the investigatory process at the SEC, it really means that it will decelerate the investigation process, but not really hinder it. And especially for SEC registrants, and in my world, that really means broker dealers and investment advisors, although that can also apply to investment companies and other SEC registrants. SEC registrants respond to non-formal requests of information all the time, also known as an exam, for example. So I don't think the revocation of authority will have an outsized impact on how investigations are done for broker dealers and investment advisors. The reality is SEC registrants will continue to respond to SEC staff requests, whether they are formal or subpoena. Where I think we will see more of an impact, however, is for non-SEC registrants and other investigation targets, whether we are talking about public companies, private companies, and other types of entities. So overall, while the withdrawal of delegated authority could mean that the process for investigation could be lengthier, it doesn't necessarily mean that it will not occur. I've seen some headlines saying that like enforcement authorities getting rolled back, on an extreme level. I don't agree with those headlines. For investigations that involve non-SEC registrants, that I think will decelerate the process more. I don't think, though, it will decelerate the process as much for SEC registrants because they'll respond anyways. One thing I do want to note, especially for investigations involving non-SEC registrants, is that voluntary requests can only go so far. So, for example, and for those of us who do this a lot, like we talk about the subpoenas to our clients when the client is the target, but there's also third-party subpoenas, in terms of bank records, auditor documents, other third parties that, may have done business with the target of the investigation, where the third party is not a target, but is asked to provide documents by SEC staff. All of that will slow down more because the staff generally cannot obtain bank records or auditor documents without a subpoena. And also for third-party document requests, I think those will raise more questions from counsel. So, if a client calls me and says, I've received this request that, in the past would have been a third-party subpoena, but now is a document request, the calculus to respond may be a little bit different. But I think overall, while the revocation of authority will change things, the reality is the enforcement division will still continue to investigate. There may be more input, and I expect there will be more input from the commission as part of this process than there was in the past. I think we will also see more uniformity across regional offices, which overall I come from a world where uniformity is a good thing. That's how I think of uniformity as a practitioner. That said, there's some regional differences between the various SEC regional offices that exist for a reason, because they are in different markets with different types of industries that may be an area of focus. Of course, I'm thinking of the San Francisco office and the tech industry, and the Denver office and the tech industry, but also the oil and gas industry. Like those things there are differences across regions that are driven by the markets in which those offices are. So, in the immediate sense, I expect to see many more voluntary requests in connection with enforcement investigations. I expect how interacting with staff will change a little bit over the next few weeks and months. That said, the business of investigating will continue. That I can think of several investigations that have opened since January 20th and would likely have opened after March 10th and the revocation of authorities. So it's a change and it will have an impact, but it's one where we can look at the last time that the framework for opening an investigation was like this, meaning pre-2009.
Yeah, no, I mean, that makes complete sense. And I think it's really helpful, what you discussed today, because I just think in this environment, there's so much information and so much going on that I think sometimes when you see the headline, you just kind of internalize that and, have a certain viewpoint. But once you kind of look under the hood, I think it is really helpful to kind of see, well, maybe things are changing, but it's a lot more nuanced than just saying that, either no more enforcement or much less. So.
Right. It's definitely going to be an area of nuances. And I know we're almost out of time, William, but I did want to note, I've heard several SEC commissioners speak over the last few weeks and signal, and they're all pushing for the fact that statutes and rules are still in place and will still be enforced. So I don't think we're going to see sort of an across the board deregulatory rollback happen all at once. I think we're going to see it first and foremost in the financial innovation and digital asset space. But I think, the reality, especially of those of us who work a lot with investment advisors and broker dealers, is exams are being kicked off every week right now, both out of headquarters and then out of the regional offices. So the business of the commission is still continuing as we would expect.
Absolutely. So yeah, great episode today. A lot to digest. Hopefully our audience finds it helpful. But again, I think, really, digging into some of these issues and talking about them in, a straightforward, reasonable way, hopefully is helpful. And, I think that going forward, we'll see if this slows down, but I have not seen any indication of that so far.
No, I think that's exactly right. So we'll go back to having more guest speakers over our next few episodes, and we'll keep unpacking all of this as it's happening. Thank you, William, and thank you to our listeners.
Thanks, Alex.